हो गया 3 चल गया
in progress.
खसीमा है Bismillahirrahmanirrahim. Assalamu alaikum and good morning everyone. I am Dr. Zahra Batul and on behalf of the organizing committee I welcome you all in the lecture series of capacity building program on management of intellectual property rights, which is jointly organized by IPR Office ICCBS, Comstech and Siren. The session will be started with the name of Almighty Allah, and for this I would like to invite Hafiz Muhammad Bilal for recitation from the Holy Quran.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم ألهاكم التكاثر حتى زرتم المقابر كلا سوف تعلمون ثم كلا سوف تعلمون كلا لو تعلمون علم اليقين لترون الجحيم ثم لترونها عين اليقين ثم لتسألن يومئذ عن النعيم صدق الله العظيم.
Subhanallah. Now, for the formal start of this today's session, I would like to invite our Director ICCPS and Coordinator General Comstech, Professor Dr. Iqbal Chaudhary, for the welcome address.
Bismillahirrahmanirrahim. Assalamu alaikum. Good morning and good afternoon, ladies and gentlemen, boys and girls. Thank you, Zahra, for inviting me for the formal inauguration of this very important event. This event is certainly has a very special significance because in the world of innovation, where science and technology need to be linked with application, commercialization, and direct benefit to the society, intellectual property rights plays an extremely important role. And all along, this has been neglected. Our laboratories in the OIC world are producing good quality science, but somehow we are not able to protect these rights of intellectual property, which has been generated with lots of efforts. And as a result, we are not able to benefit. And there are numerous examples in which the quality of work which was conducted in OIC member states in lots of good institutions have been commercialized by other institutions and in the West. And this is so become extremely important that we understand the contours of protecting the innovation, the intellectual property, which we generate with lots of work. Kindly remember that in today's world, people are always very curious and interested in understanding the outcome of research. And of course, there are lots of very important research which goes into basic sciences and technology, but a lot of it is directly linked to new discoveries, new knowledge, and those discoveries and knowledge has to be protected because this is the first step for any commercial benefit which you can draw out of these discoveries. Kindly remember that in developing world, in developed world, IPR are considered to be important. Everyone try to protect. Even a small gadget would have 300 or 400 of these patents, which are actually used in assembling of small mechanical or electrical devices. And that combined benefit eventually help in financing research. So research financing is not from the government funding alone, but also from the funding which you generate out of your own intellectual property which you generate. With this, I'd like to thank IPO Office, Intellectual Property Office of Pakistan, for partnering with International Center for Chemical and Biological Sciences and with comstech in this very important workshop, which, as I understand, is the first one of many workshops which we intend to carry out. And this would help you to understand and appreciate the importance of intellectual property right, as well as various ways of protecting IPR. With this, I would like to thank you all for your interest. I know that many people would come online from different time zones, and I wish you a very successful, very productive, very interactive event today and then days to come, because we feel that this important topic has to be pursued in future as well. Thank you, and Assalamu alaikum wa rahmatullahi wa barakatuh.
Now I would like to invite Professor Dr. Fazana Shaheen, in charge IPR Office ICCBS, for her address and to introduce our resource persons.
Respected Director, International Center for Chemical and Biological Sciences, Coordinator General, Comstech, Professor Dr. Muhammad Iqbal Chaudhry, participants from Comstech member countries, SIN Innovation Research and Education Network, and International Center for Chemical and Biological Sciences, and resource person from Intellectual Property Organization, Pakistan. Assalamu alaikum and good morning. On behalf of International Center for Chemical and Biological Sciences, I am pleased to welcome you all in this training program on management of intellectual property rights, which is jointly organized by IPR Office, ICCBS, SIN Innovation Research and Education Network, SIREN, and Comstech. This lecture series under this training program is organized for the faculty members and researchers to help them better understand the IP system globally and the significance of IP rights and IPR management strategy. These lectures will be conducted by the resource person from Intellectual Property Organization, Pakistan, and World Intellectual Property Organization, WIPO. And we expect that all participants from Siren Network, Comstech, and ICCBS will get maximum benefit from various sessions conducted under this program. The Controller of Patents, IPO, Ms. Zubia Hassan, and Assistant Controller of Patent, Ms. Saima Kawal from IPO Pakistan, have joined us today in this session. Now, I would like to invite Ms. Zubia Hassan, the Controller of Patents IPO, for her comments on this training program. Zubia, please start.
Thank you so much. Honorable Professor Dr. Iqbal Chaudhry, learned researchers from HEJ and from member countries of COMSTAC, distinguished guests, ladies and gentlemen. Assalamu alaikum and a very good morning. I am very delighted to join this capacity building workshop on IP awareness, jointly organized by IPO Pakistan, International Center for Chemical and Biological Sciences, ICCSB, COMSTECH, and SARDEN. I came to know that the series of events would be organized for creating IP awareness through this collaboration. I thank you all organizers and hope this collaboration would be fruitful for all of us in bringing change. Under IPO Act, one of the most important functions is to create IP awareness among the researchers and to make IP innovation accessible to all stakeholders. We have been carrying out many IP awareness activities from last 10 years, but we could not operate in isolation. Therefore, in 2017, we have formalized the collaboration of national and international experts in the form of TISC project. TISC, that is Technology Innovation Support Centers. They have been created in many universities and are working very well. TISC, what is the objective of TISC? It's to encourage the use of patent information among researchers and innovators, help innovators to exploit their innovative potential, and through this banner, we assist in creating, protecting, and managing their IP rights. Through IP session, we teaches researchers about effective patent database search. The patent databases search are the reservoir of the latest information in any field of technology. Countries are investing in R&D, however, the journey from the research to product is challenging. Due to these IP awareness activities, we have seen a trend, increase number of patent filing, and I am glad to share that the quality of the patent is increasing day by day. And we have seen many good inventions, those who are accepted in Pakistan, and as well as in foreign countries who have developed IP offices. But we have observing from quite a long time that all inventions are not, they do not reach the status of grant. They are accepted but they are not enforced due to the non-payment of their ceiling fee and the maintenance. So the reason is that maybe the researchers, they don't have the finances to maintain their inventions, and ultimately they are not, they could not keep their inventions in force, and they are not getting any remuneration or any economical benefit from their inventions. So our objective is to encourage the SMEs to consult patent information for new businesses and licensable technology and potential partners. And I thank you. In the last, I would like to thank all the organizers who have taken this initiative, and I hope this would be, all these sessions would be fruitful for all of us. Thank you so much.
Thank you, Ms. Dubia. Now I would like to invite our first speaker, Ms. Saima Kawal. Ms. Saima Kawal is associated with the Intellectual Property Organization Pakistan since 2006. Ms. Kawal had her MPhil in biotechnology from Quaid-e-Azam University, Islamabad, and Masters in Law in Masters in Intellectual Property from Ankara University, Turkey. During her 15 years career, she has served at multiple positions in IPO headquarters and its field offices. She has practical experience of patent examination, especially in the field of biotechnology and pharmacy. She has been dealing with technical, legal, and policy matters of patents, industrial design, and geographical indications. She is also serving as national coordinator to establish technology and innovation support centers network in Pakistan in collaboration with Higher Education Commission and World Intellectual Property Organization to educate the faculty members and students on the use of patent information. Now I invite Ms. Saima Kamal for her lecture on the introduction to intellectual property rights and understanding the patent system in Pakistan.
Thank you so much, Dr. Farzana. Thank you. I'm highly grateful to Dr. Iqbal, Dr. Farzana, and their team for inviting me and for giving me an opportunity to talk to so many researchers from Pakistan and from the member countries of comstech. As Dr. Iqbal has said, and as my controller has said, that intellectual properties is an extremely important subject for the researchers as well as entrepreneurs. It is very timely. It's very important to learn about this subject. Otherwise, your invention, your creative ideas, your brands would remain neglected. They may be lost or even stolen. So with this objective, we have designed a series of workshops covering different aspects of intellectual property rights, which we would deliver lectures and workshops throughout the 2022. I would like to give you a brief introduction of sessions which we would cover in the coming year. In this year, today is the introductory session. Then we would have a practical workshop on patent drafting, which is a skill, and there is a lot of demand and there is a lot of
need to learn how to file patent. Then we would also like to give you awareness regarding the patent document, how to read that document, because patent document has different numbers, dates, and it's a technical document, how we can retrieve different patent documents and how can we read and interpret this document. Then we would also have a session on design protection. World Intellectual Property Organization is our partner in the TISC project. And under TISC project, we would invite our experts from WIPO to have lectures on patent information. I think these lectures would be online, and our experts from WIPO would join us from Geneva. Then patent database search strategies. This is another subject which we would like to cover in this series. So with this, I would like to start my today's presentation. In today's session, I would like to give you basic introduction of intellectual property, its different form. Especially patent is relevant to research and technology, so we would talk about patent in detail. What is the significance of patent? Why we should care about patents? What are the basics of this system? Then we would also talk about some misconceptions which is generally prevalent among the researchers about the patent system. And I would like to brief you a little bit in detail about the patent system of Pakistan. I would show you the patent filing trend in Pakistan and our enforcement mechanism. So, ladies and gentlemen, you would agree with me that we are one of the most intelligent creature. I should say we are the most intelligent creature on this earth. Actually, we are the being who imagines and bring into existence what we imagine. And human imagination has given rise to countless inventions throughout the history of civilization. We have our researchers, our creators, they have given rise to literature, they have given rise to music, art, and marvelous architecture with their imaginations, with their creative ideas. So all these creative ideas constitutes intellectual property. This is the creation of human mind. We coin it into a word, intellectual property. And set of rights which are given to the inventors and creators to get advantage of their creations and inventions are known as intellectual property rights. There are different forms of intellectual property rights: industrial designs, patents, trademarks, copyrights, geographical indications, and plant breeders' rights. So these are different forms of intellectual property. I would quickly go through these different types of intellectual property. Trademark. We are all well aware of different trademarks. We hear, Gucci, L'Oreal, Sephora, Amazon, Google, Toyota, Nestle, Nescafe. So these are not only fancy words, but it gives us information about some quality products. These are commercial assets which communicate with the minds of consumers. So they give us information about our favorite products. We trust these names. And we just go and we recognize these products in crowded national and international markets with the help of these trademarks. So trademarks constitutes very important commercial asset when you want to take your product in the market. You are the researchers, but many of you would be the businessmen or the entrepreneurs of tomorrow. So it is very important to give due, to invest time, efforts, and your creative skills to create a very recognizable, catchy trademark for your business. So trademark can be a word. It can be a letter like J dot. It can be a numeral, or it can be symbol. You are well aware of different logos. Those are also trademarks. Then it can be a different distinctive phrase, slogans. There are a number of well-known slogans like just do it, naam hi kafi hai. So this can also be protected as trademark. Now these are the traditional forms of trademark, but now the non-traditional forms of trademark, they're also being granted to different names like shape marks. Toblerone chocolate, the specific shape of this chocolate is protected as a trademark. Then this roar of line, MGM line, this is also protected as a trademark. So these are non-traditional trademarks, smell marks, color marks. So these are different things with which you can distinguish your commodities in the market. Okay. Do you know what is this swoosh? Can you identify it? Can you trace it back? Nike. Okay, fine. And what is this? McDonald's. So we are well aware of McDonald's. Starbucks. Yes, Starbucks. So, so in this way, these trademarks, we just look at these pictures and we identify our product. So this is the power of trademark. Eat fresh. This is the slogan. Do you know slogan is this? Yes. Okay. Yes, it is Subway. लगता है Subway खाने वाले कम लोग हैं हम. KFC के शायद ज़्यादा हैं. Okay. So trademark and then designs are equally important. The shapes, appearance of our products, the appearance do matter. Sometimes the aesthetic value of your product make the customers to buy your product. It happens in many times, especially in the fashion industry. It is very, very important, the appearance of your products. So this is also a form of intellectual property because we invest our creative skills to come up with some creative form for your product. That's why it is regarded as intellectual property and it is protected as industrial design. But when we say the industrial design, it means we only give protection to the appearance of that product and that's it. It has nothing to do with the underlying technology and functioning. It is just relevant to the appearance. So two-dimensional, three-dimensional products, both can be protected. Their designs can be protected, or there can be single product, there can be set of products like crockery set. And the protection of trademark is basically 10 years and with the renewal of 2 terms for 10 years. So collectively it is 30 years. So trademark protection is also an important form of protection, which is, we are under obligation to give this protection under TRIPS. This protection is available in almost all members of TRIPS. And protection term is almost 20 to 25 and 30 years, which can vary a little bit. Then there is copyright. Copyright is basically a right which is given to the artistic literary work, which may include books, music, painting, sculpture, films, computer programs, software. These are all subject of copyright. So copyright covers all these things. You're he's well-known singer, but it would be a surprise for you people to know he is the highest paid dead celebrity. I mean, even after his death, he is earning. He is earning because the copyright system is very strong in his country. And from 2009 to 2020, he was the well-paid, he was the highest paid dead celebrity. Another legend, another celebrity of Asia. He was also a great singer. He produced marvelous music in his life. He died in 2012, but his outstanding bills were paid by the Sindh government. He was not able to pay his bills because unfortunately he belonged to a country where copyright system is not that strong. We don't pay royalties to our artist. We don't have strong mechanism of collective management of copyrights, which is present in other developed countries. So in this way, the copyright system is, if effectively enforced in a country, can reward your artist throughout their life and 70 years after their death. So after 70 years, their creations, their music, their films, their books, they would be in the public domain. Then anyone can use that work without their permission. So this is how copyright system works. Then there is another form of intellectual property, which we say geographical indications. This form of intellectual property, it is very relevant. I should say, it is equally relevant for the developed countries, developing countries, and least developing countries. Basically, it belongs to the family of trademarks. Geographical indications are basically the marks which are given to the agriculture and the industrial products who have some reputation attached with the environmental or human factor of its origin. They have special link with their origin. For instance, basmati rice, it's special aromatic rice, which are only grown on the foothills of Himalaya. It's only grown in Pakistan and India. So they have special association with that area. So basmati rice is protected as GI. So in this way, geographical indication, most of the developing countries and the least developing countries, they are not very well in science and technology, but they have rich treasure of geographical indications, such agriculture and traditional products, which can be protected as GI. Quite recently, we have passed geographical indication law in 2018, and now we are protecting our traditional and regional products. So if we see internationally, Panja pepper, this is the geographical indication of Cameroon. Roquefort cheese, well-known. Blue cheese, it is the product of France. Then Tuscany olives, it's argan oil from Morocco, and basmati rice. So these are the products which are protected as geographical indication. Then another field of research and innovation is agriculture, and there are a lot of work going on to produce new plant varieties. This constitutes a separate form of intellectual property, which is known as plant breeders' right. And in our country, we have standalone separate law for plant breeders' right. Internationally, different countries have different arrangements. Some countries like US, they gave a grant patent to their plants. But in Pakistan, we have a standalone law for the protection of plant varieties. So in this way, the plant varieties are protected. We would focus more about the patents in this presentation. Actually, what is patent? I think it's a very basic question, you all know. But actually, patent is an agreement between the government and the inventor. Government grants monopoly or an exclusive right to the inventor to exploit his invention in the market, and in return for that exclusive right, the inventor discloses his invention. This is how the system works. There are two aspects, the protection aspect and disclosure aspect. So this is, common all over the world. This is how the system works. These are the rights which are granted to the patent owner under TRIPS. He has exclusive right to make, use, sell, offer for sale, and import his patented product in a country. Patents and intellectual property, they seem a very modern concept, but believe me, this concept has been present since the origin of, throughout the development of our civilization. Patent-like monopolies have footprints as old as 600 BC, when chefs were granted, monopoly for 1 year for producing some specific recipes. So first formal statute was passed by Italy, Venetian Patent Statute 1474, under which patents were granted to the inventors. Then the Statute of Monopolies of England, this statute have impacted, was a sort of parent statute, and it has ultimately given rise to patent legislation in Commonwealth countries. And under this statute, 14-year monopoly was used to grant it to the inventions. Then after the Industrial Revolution, a need for international patent system was felt, and Paris Convention was signed in 1883, and it was the first effort to harmonize the patent practices internationally in the member states of this agreement. Then another milestone in the history of patent system is PCT, Patent Cooperation Treaty, that was signed in 1970. This is basically a filing system under which you can seek patent protection in multiple jurisdictions with single application and with minimal formal requirements. Then with the discussion of free trade and World WTO, once again, the need for a well-strengthened and well-enforced intellectual property system on the international level was felt, and TRIPS was signed by the member countries of WTO in 1994, and the modern patent law is governed under the TRIPS. So actually, patent is very costly. It's very lengthy process. It's resource intensive. You have to give a lot of time. You have to make a lot of efforts to get patent. So why we should go for patent? What is the point in patenting? First of all, patent rewards the creative minds, as this is the basic rationale of patent. There are many inventions in the history about which we don't know who invented those products. This is the patent system which actually grant patent, give ownership to the inventors, and they reward it in the form of exclusive marketing right in the market. Then it encouraged investment in science and technology, because when you are patent owner, you are in the market, you enjoy a sort of a dominant position in the market, and you have an opportunity to recoup the investment. Then you get encouraged and you invest more. So this is how theoretically this system should work. An example is given, I mean, in case of pharmaceutical products, which needs millions of dollars to develop a new drug, but it is very, very easy to copy and to reverse engineer that product. So if there is no patent system, then the original researchers, the original inventors, they would get discouraged, nobody would invest in the research and development because of copycats. So that's why it is very important to have a patent system, to have a reward, to have a proper opportunity for the companies who invest in R&D to recoup their investment. Then it avoids the stealing of your ideas. You would agree with me that in this highly connected, digitized world, it is very easy to copy. Copying has become very easy. So it is very necessary to protect your creative ideas. Otherwise, someone else would steal your ideas, and in worst condition, he may get patent on that idea, and he can bar you to use that product, which was originally yours. This happens. This actually happened in the history, where because the patent system all over the world, they follow first to file system. The one who comes to patent office first, his application is accepted. So in this way, it is very important to protect your creative ideas, to go to the patent office, to have patent in the first place. Then patent constitutes prima facie evidence of your ownership. It's a legal document. Even in the court of law, it is presented as a proof of your ownership. and burden of proof would lie on the other party if there arises some dispute on the ownership of an invention. So that's why the patent gave you a sort of legal ownership on your invention. Then, in the present, there is growing emphasis on not only research and development, but also on the commercialization of research. So our universities, R&D institutes all over the world, they are under pressure to commercialize and their research outcomes. So it is really hard to imagine commercialization without patent. Patent gives you an opportunity of licensing your product. I mean, unless and until you don't establish your ownership on your product, how can you license it? How can you commercialize it? Nobody would enter into licensing agreement or into a commercial agreement with you unless you have a patent, you have proper ownership. So you can use your patent document to license your technology and to transfer, or you can transfer your technology for lump sum payment. So there are different technology transfer opportunities, and patent is regarded as best tool of technology transfer. Then patent enhances corporate value of your companies, of the institutes, universities, R&D centers, and it also give value, added value to your CV. Just like your publications, patent is also an important indicator of innovation. It shows how much innovative activity is going on in a university or in an institutes. So that's why institutes, companies, individuals, they should care about patents. Then this aspect of patent is most important for me, and this is also one of the prime objective of patent, to encourage the disclosure. I mean, mostly even in the history, and most of the researchers, they are they don't they are afraid of disclosing their invention, because they are afraid that their invention, their creative idea would be stolen. But patents say, just disclose your invention, we would give you a statutory right to get advantage of your protection. For instance, such fear of being stolen, the ideas being stolen, exists throughout the history of science and technology. The inventors and the researchers in 1873, they refused to attend an international exhibition and to display their products, because they were afraid that their products and their ideas would be copied by the other countries, by the other researchers. So they refused to join this international exhibition. Similarly, Da Vinci, he was a very well-known painter, but he was an inventor. He designed his creative ideas, but he was used to write in mirror handwriting, because he don't want others to know his inventions. So, like, this is the actual script of his from his notes, where he writes. He tried to, conceal the information, the technical information regarding his invention. And patent is anti to this system. Patent encourage you to disclose. So when you disclose your invention, patent becomes a huge resource of information. It is very unique resource of information. This picture at the right side, this is the actual picture of USPTO, United States Patent and Trademark Office. Initially, the patent document which you submit to the patent office for patent grant was stored in hard form, and it was very tedious to search those documents. But currently, these documents are stored as very sophisticated patent databases, and it is very, very easy to store those products, to store those documents. And but these patent databases are underutilized, not only in our country, but in many developing countries. So one of the objective of patent system, one of the objective of IPO Pakistan and World Intellectual Property Organization is to educate our researchers to use these patent databases. I mean, you people use books, libraries, you perform Google search, but very, very rarely you people use patent documents, patent databases. This is very important resource of information. We would have separate session on this, how to explore patent databases. 77 million patent documents are stored in these documents, and these patent databases are, the collection is increasing every year. Then it contains state-of-art patent documents because patent inherently granted to new technologies. And there are different databases which are freely available. I mean, it's the very important characteristic. You don't have to pay any subscription. You have to learn how to retrieve. These are all freely available patent databases. Okay, there's some important information about the patent system. Actually, patents are territorial. I mean, if you have a patent in Pakistan, it is only valid within the boundaries of Pakistan. If you want to have commercialize your product in the China, then you have to go to the Chinese patent office for to have patent protection in China. So patents are territorial. There is no concept of international patent. Yes, PCT gives you an opportunity to file application with minimum requirements, but there is no such concept of international patent. Every country have their own patent system and they have their own patent protection. Patent lifespan is 20 years, and this is also standard under TRIPS. This term is defined in TRIPS, and all the TRIPS member countries, they have minimum 20-year protection for patents, after which the patented technologies becomes public domain. Then there is another misconception about the patent that it is granted on some very complicated technologies. But look at these products, how simple they are. Any simple product with some creative idea can be patented. These are the product, I mean, sticky tape, and what can be more simpler than rubber band? This was the patented product. And we can't imagine our life without these products. I mean, they are so useful. Then the paper clip, Lego, and Post-it, these are all simple inventions, but they were patented. They enjoy patent monopoly. So any simple or complicated or invention from horseshoe to avionics, anything can be protected. Then for to have patent, you need not to have special degree. There is no age limit. Anyone can file patent. Meet Samuel Thomas. He's British inventor. He's 5 years old. He's patent owner. He has invented a two-head broom. He used to clean lawn with his father, and he came up with the idea of combining two heads. And his father was, by the way, patent attorney. And in this way, he became patent owner. He filed patent application, and now he's one of the youngest patent owner. Then it is considered perhaps the patent and publication are somehow contradictory to each other. But no, patents are not contradictory to the publications. You can make publication as well as patent the same technology. But there is only, you have to care about the timings. So I know your slogan, publish or perish, but just slightly change it. First patent, then publish. So you have to file your patent first. Then you can publish your invention, you can license your invention, you can commercialize your invention. Because once you have filed your invention in the patent office, you have secured the priority number, I mean the priority date, the filing date, that is important. So after which you can publish freely. Yes, yes. Because it happens when you publish and then you go for patent, usually your own citation becomes novelty destroying document for your under process patent applications. But yes, there is a grace period. There is a provision of grace period in some countries. Basically, the grace period is a period of 12 months, in some countries 6 months, under which if you have published, but that would not be counted against your patent application. But this provision is not as such available in Pakistan. In Pakistan, there is limited scope of grace period. What is available in Pakistan, you can claim grace period protection for only mechanical object which has been displayed on some international exhibition, and then even if it is displayed, you can file patent. You can say you can seek protection of grace period. But in other countries like in US, the grace period clause, it is very well detailed, and there is 12-month period grace period where you can publish your invention and then you can file your invention. So where to file patents? As you know, patent, I would say it's very costly and resource intensive procedure. You should do proper homework before filing the patent. You should do proper novelty search, and you should be confident that your invention is new. It would get patent. It is not disclosed. It is not already in use or published somewhere. Then you have to work out where you want to get patent. I mean, it's very costly. In Pakistan, the patent fee is not very much, but in other countries, its fee is very high. Like in US, it's very, we have to pay a lot of fee to the attorneys. And so that's why it's very critical decision when you are going to invest your money. So there can be 3 routes when you think to file patent. First, national route. You can file to your national patent office and go to your national patent office and file patent. Then there is regional routes. There are some regional patent offices like European Patent Office, like African Intellectual Property Organization. So these are regional patent office where you can file one application and you can get protection in all member countries. So this is also sort of patent arrangement exist in different countries. I think ASEAN, Africa, they have 2 regional offices, European Patent Office, Nordic, they have also Denmark, Sweden, Finland, they have collectively 1 office. So in this way, regional offices exist and you can follow regional route depending upon your commercialization intentions. Then international route. International route mean PCT, I mean Patent Cooperation Treaty. With this is only unfortunately available. It's not available to us because we are not member to PCT, but we are making preparation to become the member of PCT. So the members of PCT and the nationals of those countries who are member to PCT, they can avail international route. How to enforce your rights? Once you have patent, you have become patent owner. Now what to do next? I mean, patent is a civil right. If someone infringe your invention, if someone try to copy your invention, it is you who have to initiate a legal action against the infringer. I mean, police, FIA, they would not help you. I mean, it is you who have to initiate the action. So because it's a civil right. So infringement suits, usually the penalties in the form of damages are claimed, and stay orders are also possible in different countries, but mostly in lot of countries it's a civil crime, and the penalties in the form of damages can be claimed, and damages are very high damages. So that's why usually in patent disputes, out of court settlement is more common. Yes, there is another. If your application is under process, it's not granted. still you can use patent pending on your commercialized product. This patent pending would make your competitor aware that your patent is under process and it would be granted. But the patent protection is only starts after the grant of patent. When you get patent certificate, after that you can sue someone. But yes, before that, until and unless your application is under process, you can write patent pending. But be careful, this patent pending, writing patent pending on a product, the application of which product is not filed is a crime. It has punishment. So that's why we should be use patent pending carefully. Global filing trend, patent trend is increasing. It's ever increasing. But it would be very interesting to know that we are almost, I think, around 200 countries in the world, but almost 5 offices constitute 85% of total international filing. And China is the leader, and China has surpassed US in patent filing. So it's very interesting story of China from a copycat in 2005 to the leader of patent applications in 2020. It's really impressive. Almost 1.4 million patent applications were filed by Chinese inventors in 2020 internationally. Now we would talk about the patent system in Pakistan. This is the Bible of patent in Pakistan, Patent Ordinance 2000, and we have rules, patent rules 2003. All procedures and all systems of patent office work under this ordinance. We have presence in 5 cities. We have, presence in 3 cities. Karachi, Islamabad, Lahore. Yes, we have newly opened our receiving office in Peshawar. So you can file, our main registries are in Karachi, our headquarters is in Islamabad, and we have regional office in Lahore, and we have another receiving office in Peshawar. As I said, anything can be patented, but still there are some exceptions which varies from country to country. According to Patent Ordinance 2000, any new process, product, and improvement of these two can be patented in Pakistan. So we receive a number of patent applications and from different fields of technologies like related to the mechanical devices, chemical compounds, including the pharmaceutical compounds and pesticidal compounds. Then we have improvements of anything, any product or chemical compound. Then we have genetically modified sequences. We also receive applications for genetically modified microorganisms or the newly isolated strains of microorganism. Then we have new processes of different products. These are also patented in Pakistan. However, as I said, there are certain exceptions to patents. As I said, anything which is disclosed cannot be patented. Then non-technical subject matter, if it's a scientific theory, it's mathematical method, literary, musical, artistic work, these are all come under the copyright, but you cannot have patent on it. Substance that existed in nature or isolated, therefore mere isolation is not patented. But yes, if you have some novel way of isolating that product, or if you have discovered research some novel properties of that natural organism, like the microorganism, they are naturally present, but if you have came up with the novel use of that microorganism in leather industry or something, wastewater management or like this, then you can file patent for it. Plants and animals per se are not patentable. Then inventions which are against any of our law and order or morality standards of our country, that would not be patentable. Then second use of already known product, like Disprin, it's a common example. Initially it was used as a headache, but now it is used as blood thinner. This is the new use of already known product. This new use of already known product is not patentable. Then mere physical change when chemical composition is same is also excluded from the patent protection. Who can file patent? In Pakistan, any Pakistani citizen or any foreigner, they can file patent in Pakistan. True inventor can file himself, or he can assign his right to his institutes. I mean, it's very common practice that the employees of universities and R&D institutes, they assign their inventions to the institute. Their inventions are filed by their university or R&D institute, but their name as an inventor always remain part of the patent application. Then he can file himself, or he can hire the services of an attorney. There can be a single inventor, there can be a multiple inventor, which can come together, they can file joint application. Legal requirement for patentability in Pakistan is available in all other jurisdictions of member countries of the TRIPS. There are basically three standards: novelty, inventiveness, and industrial applicability. These are the three criteria on which we assess your invention. Actually, novelty criteria is very, mechanical. If an invention has four parts and your invention has 5 parts, we would say your invention is novel over the existing invention. It is very mechanical. But actually, it is the inventive step that matters. Basically, a number of applications are refused owing to the lack of inventive step. For instance, this is the chair with 4 legs. By the way, this is very, very simple invention. Inventive step is very technical criteria. Anyhow, just to make you understand, this is the chair with 4 legs. It is the prior art chair. And some inventor came up with a chair with 5 legs. It would be refused because it's very common, it's very obvious to the person in skill in art to attach 5th leg. It's very obvious. But yes, if you have rocking chair or you have a chair with wheels which solves some problem, which make your product, already existing product, movable, and it solves some other problem, then you can contest the inventive step of your invention. Another important decision which you have to make during your research is which type of application you have to file. Either you should file a complete application or provisional application. This provisional application is a sort of relaxation, which is facility which is available in our patent ordinance, and it is filed usually in different scenarios when there is an urgency. You have apprehension, somebody would steal your idea, you can quickly go and file provisional application. There can be situation you want to license your invention, but before that you want to get patent protection. There is not time to write claims, you can file provisional application. You have to publish your invention, you can file provisional application. Basically, provisional application is filed with very few formal requirements. Its fee is half, and you have to just file the form and a broad sketch of your invention without claims. So it is very, very easy. You can file very quickly. This provisional application gives you a time period of 12 months under which you have to file the complete application. If you don't file your complete application, your provisional application would be abandoned. Filing of complete specification, you need broadly 3 things: forms, fee, and patent specification. Just like your journal article, the patent specification is also a very technical document. It has some requirements. You have to write the title, abstract, field of invention. You have to give the problem existing in the existing inventions of your field of technology, detailed description, drawings, and then claims. Basically, the claim is the crux of your application. It is the claim which defines the boundary of your protection. Even in the court of law, in the patent offices, claim sometimes is the only part which is examined. And something which is disclosed in your specification, but you have not claimed, you cannot claim the protection over that. So that's why the claims are drafted very meticulously, and usually the services of experts are hired to draft the claims, and we would have a separate workshop to give you basic idea how to draft claims of patent applications subsequently. Generally, I would like to give you an idea what happened to your application in the patent office. You file your application. It is a formal examination is done just to check the fee, correct forms, and the power of attorney. Then it goes for substantive examination, novelty, inventiveness, and industrial applicability. If it is fulfill all three criteria, your application is accepted. Once application is accepted, it is open for opposition. Opposition period is, sorry, not 90, it is 120 days. During this time period, anybody can oppose your invention. If your invention don't receive any opposition, it is accepted and patent document is granted to you. Congratulations. But if someone opposes your application goes to the opposition procedure. Then there would be argument from the both side, and controller would decide. If controller make decision against you, you have option to go to the court against the decision of the controller. Enforcement mechanism of IPRs in Pakistan, we can say it's gradually strengthening. We have separate courts for IP cases. IP tribunal. These tribunals are working in 3 cities, Islamabad, Karachi, and Lahore. All infringement suits are filed in these tribunals. Then against the decision of tribunals, you can go to the High Court and then Supreme Court. And obviously, just like other countries and just like TRIPS requirement, it's a civil right. You yourself have to initiate the action against the infringer. Finally, I would like to share some statistics related to patent filing in Pakistan. Patent filing in Pakistan is not very, it's not very high as compared to the regional countries. On an average, we receive 800 to 1,000 applications annually, out of which almost 300 to 400 applications are filed by our local inventors, which include universities, R&D institutes, individual inventors, SMEs. I mean, all these together file almost 300 to 400 patent applications. But it is encouraging for us that at least for last 5-6 years, patent filing by our local inventors is increasing. So we are happy about it. In 2016, it was 2,204 applications by the residents. And in 2021, we received 374 applications by our local inventors. So that's why we have made one of this objective of IP Pakistan to create awareness and to build the capacity of our stakeholders so that they may come to patent office and they may seek protection for their research. Thank you.
The session is open for the question. You can ask any question, and the online participants can also participate.
Can I ask a question?
Gigi, please.
What benefit does one have to write patent pending on the product?
Yes, it is. Let's say you want to place your invention in the market. It's a sort of warning for your competitors that your patent application for this product is under process. Once you would get patent, you can sue the infringer. It's a sort of warning for the potential imitators.
But once your patent is published, you already have that kind of rights that whenever if anyone is going to copy because it is already published, then it will be counted like it can be sued to someone.
No. Right to sue.
Equivalent.
No. Right to sue someone is only available once you have granted patent. It is only available once you have patent certificate, once you have become patent owner, then you can sue someone. You have filed application, you are patent applicant. There are 2 possibilities. Your patent application can be refused, can be accepted. So you can't sue anyone. But yes, you can write patent pending. I mean, it's an information. It's nothing wrong with
That goes more for the daily commercial products,
yes,
right?
yes, obviously, and it gives value if you are negotiating licensing agreement for some commercial partner, and you can say the patent for this product is under process, and you can write patent pending. So it would give value, I mean, to your side.
Okay, but apart from that, legality is not.
But legality in a way that it's a sort of warning, it's a sort of information for the others that your application, but it is legal to write. And the companies and businesses and the inventors whose product are in the market, they write so. Because patent is very lengthy process. It may take 5 years for the final grant, but until that, you can say that your application is under process, and it's a sort of can generate sort of warning for the inventor.
Now, as far as the national, regional, and international patents are concerned, if you are granted with the national patent, right? And in that case, if anyone wants to patent almost similar idea or the same thing almost at the regional level or international level, why it will not be counted as the prior art?
I mean, if what I have understood, actually, when you file a patent application anywhere in the world, I mean, in the National Patent Office, in the Regional Patent Office, or internationally in the PCT system, you have 12 months to file your application anywhere in the world. You have a priority period of 12 months, under which you can file in the regional. Let's say you file your application in your national office, then you can file your application in the regional office for regional protection in, let's say, Africa or Europe within the 12 months, within the period of 12 months. This is how this
But
is.
that goes for me, right?
Yes, yes.
If I have a product like this, or a water bottle, I patented it at the national level, I want to go for the regional and then for the international one. But once I have been granted the patent for this bottle, even if I don't go for the regional or international one, anyone who wants to file
no one can, because the novelty is absolute novelty, and novelty is international novelty. Let's say we check, when I say novelty, I check novelty internationally. You have filed this invention in Pakistan, but if it is already filed in China or US, I would cite that document to you that your invention cannot be patented because it is under filing in
and
US.
vice versa.
Yeah, it's vice versa.
In Pakistan, it will be going to protect me internationally.
Yes, no, it's not a sort of protection. Protection is regional. I mean, once patent is granted, the protection is regional. But novelty, we check the novelty internationally. No one can take patent protection. I mean, if you have filed your patent here, but your patent protection would be regionally enforced. I mean, it would be only for Pakistan. You can't say to your patent to be enforced in US if you have not filed patent in USPTO.
But at the same time, nobody can file.
Nobody can file. Yes.
Or in the
yes. Yes.
Only the product they can make, but the patent they cannot file.
Yes, obviously they can make your product because you have not sought protection. Okay, fine.
Thank you, Madam, for giving this awareness session regarding patent. My question is regarding to what we can patent and what we cannot. So, can we apply for patent for an innovative idea regarding, for example, for something to be done, or maybe idea work for that?
Yes. Actually, a patent examiner assess your invention with the application and the specification which you have filed. We don't visit your laboratory to see if it is actually produced or not. What we have is your specification, which you have submitted to the patent office. So most of the patent applications are filed at very earlier stages before the product actually becomes a workable market commodity. So yes, theoretically you can file, but it should be a complete disclosure how this invention would work. It's industrial applicability, the third criteria, which is which demands that your application and your filed invention should be workable. Yes, in this way.
I'm asking this question because most of the time these days our digital world is basically making so much progress, and they are making algorithms, they are making new set of instructions in computational sciences. So I'm asking because can we make such instructions or algorithm as a patent application in a database, for example?
No, unfortunately not. Actually, in Pakistan, as I said, algorithms, these are excluded subject matter. Software comes under copyright, but in some countries like US, softwares are patented. But as far as the Pakistan is concerned, you have to see the jurisdiction of concerned country. But in Pakistan, algorithms, softwares, mathematical methods, these are all excluded subject matter.
Can you do a slide before the one where you have shown who can file patent?
Who can file patent?
A slide before this one.
What is not patentable?
Yeah, exactly. Okay. Now it says the plants and animals are not patentable, but before you said that the microbes are.
No. Yes, true. Your understanding is right. Plants and animals are not patentable, but microbes are. Yes. I mean, all living things are not excluded from patentability. Only plants and animals per se are not patentable, but yes, microbes are patentable.
Even in plants, what if I induct some genetic modifications in the plant?
Yes,
like foods,
obviously. Yes, but in such cases, you can claim genetically modified sequence, which you have inserted. But a plant per se would be protected as a genetically modified plant variety in plant breeders' right, which is a separate piece of legislation. But in patent application, yes, you can claim that genetically modified sequence. Yes. Oh, yes, there was a question.
Thank you so much. The question is, what is the general timeline or time duration from filing the patent till we receive the process?
This is the patented question which we receive almost in every session. Yes, patent, as I said many times, patent is lengthy process, not only in Pakistan, all over the world. Generally, it takes 24 months at patent in Pakistan. But rest, I think if controller want to say something, because patent office Karachi, patent office Pakistan, we are working with a lot of limitations. So I think if madam would like to add something.
Because we issue the first examination report after within 12 months, or maybe sometime it may exceed 12 months. So after that examination, in that examination report, we generally raise objections, sometimes formal, and if it has any formal objection with respect to
you can hear me?
all the formalities. And but the basic substance takes time. You have to search your invention in our local databases as well as the international databases. First, we determine that your application or your invention has the requirements.
really
You can
requirements.
hear me?
Novelty, like it should be new, should not be known to any person, and should not be published. And the second step, the second requirement is the inventor step, that it should not be obvious to a person skilled in the art. It is not very,
Hello.
to come up to this invention. Okay. And third is the industrial applicability. It must not be an idea. It should be
Hello.
from idea to
Hello.
it
जी जी
must
आप
Hello.
डॉक्टर सरवत इकबाल से बात करना चाह रही हैं
application that it must be produced.
Hello.
After checking all these things, we raise the objections.
डॉक्टर सरवत इकबाल से बात करना चाह रही हैं
Once we have received your reply, it again examine your application that how you have complied with the objections, and we are facing the problem with the local inventors in drafting the application. Drafting of a patent application is an art. It's not easy. Usually, researchers and inventors worldwide, they take the expertise of the qualified and skilled attorneys, patent attorneys, who have done in drafting. Because writing a research patent journal is different than drafting. So sometimes in Pakistan we have and we also have very few examiners. So that's why due to the backlog, usually we try to process the files as early as we can. But most I think average time is 4-5 years. And sometimes if it's very well written and it has no issues, it can't. Thank you.
Okay, I have, let me answer a few questions which I'm receiving. Dr. Saida Sohela Naz, she's asking, can we publish patent from published thesis? Actually, I think I would say no, because your published thesis is just like your published journal article, and it would be cited against your filed application if it comes in the novelty search of examiner. So technically, your application, your invention is disclosed once you have published it as a part of thesis. Is there any fixed or recommended hierarchy for filing patent from regional, national, or international, or one can file anywhere? Yes, you can file anywhere, but yes, in Pakistan patent law, it is written you have to file first, or you have to just seek permission to file outside. First, you have to seek permission from Pakistan, or you have to either file in Pakistan. If you don't want to file, at least you have to seek the written permission from the controller before filing outside. I'm not sure about the other jurisdiction, but then you can file regional and international. You can file application via PCT, depending upon where you want to commercialize your product. If you want to commercialize your product in a specific region, let's say ASEAN, you may go for their specific patent office. I think they have also a regional office for ASEAN countries. What is patent registration fee or organization supervisor? Who is paying? I mean, it depends. We don't have any objection who pays. I mean, it's your according to your IP policy of your institute. But patent fee is 6,000 something. 6,700 in Pakistan. Is there any fee to apply patent and then patent processing? Yeah. The initial filing fee is 6,700. Then during correspondence, you have to pay a little bit, 1,500 for every office action. And in the end, you have to pay 5,000 as a sealing fee before the grant of certificate. Yes.
Now, can I ask you a question? You see the international patent that grant you copyright for how many countries? International patent.
Oh, PCT, okay. Okay, PCT basically grants, enable you to seek patent protection in all PCT members. Currently, there are more than 150 PCT
Only
members.
members.
Only
PCT
member
members.
country, yes, only member.
Regional gives you right for only region.
Yes, but
And
they,
national gives you rights for the national.
yes, but there are many regional patent offices which are also sort of member of PCT.
That's okay.
Yes,
PCT covers those countries who are the members.
yes, yes.
Let's say I'm not a member of the PCT. Nobody can stop me. I cannot file any patent or anything closest to that one. But let's say for some chemical XYZ, then I synthesize that chemical in my country because I'm not a part of a member of the PCT. I'm not the member of the regional, and I'm not coming under the national patent office of any country. In the
Yes.
same way, like my patent can also let anyone
Yes,
synthesize.
actually, yes, it's very good question. Actually, you can make any patented invention which is not patented in Pakistan. You know, if it is, let's say, if it's a patent of some inventor who is Chinese inventor, but he has not sought patent protection in Pakistan, you can make your invention. You can make his invention, but of course, you cannot apply patent for that. Because yes, you can sell it, you can make it.
So what benefit the patent you will have?
His patent protection is limited to Chinese. You cannot export in China because
But I can export to any other country.
Yeah, in any other country, yes, you can. So that's why it is his responsibility. He should secure potential markets. If his invention has market potential, he should have secured possible markets. But he didn't. Then you can
with the
take
creation
advantage.
and ideas of other, we can commercialize in some other region.
Yes, it happens.
In that one, and I can get the commercial benefit.
Yes, it happens. That's why we say the patent is territorial. Very big giants, big multinational companies, pharmaceutical companies, they try their level best to cover almost all possible markets where they want to market their product. But yes, if there is available space, you can.
Anybody in Pakistan can use that activity and that patent for the legal activity, and you can synthesize the same compound which this has done. So what is the use of getting?
I mean, why you didn't get patent in Pakistan?
So it means we should first apply patenting in Pakistan.
Yes, it is legal. It is legal requirement. Basically, you should, because this is you can say it's also lacking on our part. We should create awareness among the researchers who file patent in other countries that first please file patent in Pakistan before going outside. But in your case, yes, if you have not protected your invention in Pakistan, anyone can use that invention, but no one can seek patent protection. But they can use. Yeah, they can use. Yes. Yes.
Our section 26 of the Patent Ordinance 2000, it talks about the, residents of the Pakistan who could not apply outside Pakistan without the prior permission of the consulate. First you have to file the patents in Pakistan, and after 6 weeks you can go and without permission you will file. But if you are not willing to file in Pakistan, first you seek foreign filing license, and for this you have to take permission from the controller, and you have to submit your invention, what is your invention about. You should have to examine it, that it must not be in contravention of the section 25, which is related with the secret inventions. That there is no such invention is allowed to file outside Pakistan, which is detrimental to our national security. So we need this requirement under the section 25. So for us, and under section 26, every researcher has to first file patent in Pakistan. This will also help us in asserting our innovation index, how many inventors are filing. And also we need to check Section 25 secrecy regulations. Thank you so much. And it's an offense and it has a punishment and fine as well.
But very few know actually.
Offense
But to
of
cut
filing
law.
somewhere else before filing within the country.
But this only filing is required, or it needs to be granted as well?
Only filing.
Only filing is required.
Even filing is not, I mean, if you don't want to file, don't file. But you have to take permission. You have to let the controller know, because there is a separate clause, as controller has said, that entitle the patent office to see the invention which are contrary to national defense or national security. So that's why it is necessary to get permission. But this is the art.
Common in many
Yeah.
countries. So it's not and also you mentioned that if we don't receive response to the
You can go for filing abroad. Yes. Any other question? There was some raised hands. आप allow करते हैं. Mr. Javed Iqbal, if he wants to ask a question, he can.
Thank you so much, madam. It was indeed a very comprehensive package on patent and patent filing in Pakistan. Actually, I was asking question in the middle, but then you explained. My question was that what is the maximum duration for registration and patent fee? But that you already explained. So thank you so much. My question was regarding that.
Hello.
Dr.
Hello.
Dr. Zina?
Hello. Can you hear me?
जी बताइए जी.
My question is that if you have right of filing the patent in Pakistan and your Pakistan grant your patent patent number, and if you have planned to export the product in other country, you have eligible to patent in every country those are manufacturing these products.
Yes, if you have filed a patent in Pakistan, you have 12 months to file your patent in any country of Paris Convention. But you have a limited time period of 12 months. Within that 12 months, if that 12 months is lapsed, then unfortunately you cannot, because your already published application would be cited against you. But within 12 months, yes, you can.
Thank you very much for a very nice question.
Thank you. Okay, thank you.
Thank you, Ms. Kawal, for such an informative and interactive lecture. Thank you all for joining us and to be a part of this initiative. Hope to see you in the next lecture. Thank you.
The next lecture is on